Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about the hot coffee case. I'm an attorney in Michigan and I've taught law school as well. And when I talk about the law on my channel, I have people ask me from time to time about other cases. They say, Steve, can you comment on this case or that case? And quite often it's a case in the news. But of course, there's the famous hot coffee case. And I'll admit, there have been documentaries done on this, books written about it, articles written about it. You can go onto Wikipedia and look it up if you want. But people say, well, Steve, what's your opinion of the hot coffee case? So I'm not here just to tell you about the case. We'll talk about my opinion also. But I do believe that many people misunderstand what that case is all about. And it's unfortunate because much of that misunderstanding came from the fact that various business organizations decided to hold that case up as an example of something that they thought was wrong with the legal system. And in doing that, they trashed the plaintiff, the woman who brought the case. And it's unfortunate because, history is history. Historians write books about what happens in history. But unfortunately, sometimes recent history is more at the hands of the media. And some people in the media have different agendas and so on. And of course, when big corporations take out advertising campaigns against things or in favor of things, and I believe at the time they were pushing for tort reform. And so they'd often explain the story about how this crazy woman in New Mexico got all this money for something stupid she did. So in case you are unaware of what I'm talking about, the woman's name is Stella Liebeck, and she's no longer with us, but Stella Liebeck was a 79-year-old woman in New Mexico who went to McDonald's one morning and bought a 49-cent cup of coffee, and that was at the drive-thru. And you may have heard about this story, and if nothing else, you've heard these facts, and that is that somehow she spilled the coffee on herself and was then awarded $2.86 million by a jury. And people say, wait a second, I can go to McDonald's and spill hot coffee on myself and sue them and get $2.86 million? There's something wrong with this world. And one of the things that I like to point out to people is many of the facts that you've heard actually are either not true or they've been spun or they've been stretched or conflated or something. But the facts of the case are a little different. I'm not saying you'll agree with the case after I tell you the facts, but it does draw things, I think, into a little bit better perspective to understand the facts of the case. So first of all, Stella Liebeck was not driving. I remember hearing people say this woman was driving a Corvette and she was, ripping around town. No offense, I don't know of any 79-year-old women who drive Corvettes. Maybe there are some out there. But she was the passenger in the car, not the driver. And the other thing that was important to know was the car was parked. The car was not moving when she spilled the coffee. So she was not driving a car, meaning that her hands weren't on the wheel while she was trying to juggle things with her other hand. She was the passenger in a parked car. So the car itself doesn't really play into the story that much, except for she obviously bought the coffee at a drive-thru, and she didn't have a table. She was not at a table. So if she bought the coffee in the restaurant, she would have been sitting at a table, presumably, when she went to open up the coffee lid. So what happened was she was in a car driven by, I think, her son, but driven by somebody else. The car was parked, and she had this coffee, and she went to open it up. And of course, if you're sitting in a car and you've got a cup of coffee in your hands, you go to open this up, and it's above your lap. And so when she went to open this up, it spilled, and she spilled the coffee in her lap. As a result of the coffee spilling in her lap, she got third-degree burns on her lap area. And I'm going to be delicate by saying that. If that doesn't make you cringe, guys, I don't know what else could. But she got third-degree burns. She then went to the hospital. And she spent 8 days in the hospital, where, among other treatments, she got skin grafts. They had to graft skin to fix the injuries from those third-degree burns that she received in her lap area from the hot coffee. Now, here's the thing. I know some people are still saying, but wait a second, Steve. She's burned by coffee. Coffee is hot. I mean, Seinfeld did an entire episode about this where Kramer spilled coffee, and, don't you know coffee is hot? And that, of course, gets us to the real question here, which we'll discuss in a moment. But first, I have to tell you that before she filed suit against McDonald's, Stella Liebeck offered to settle the case. And she actually just added up her medical bills and the time and money that I think her daughter lost because her daughter took time off from work to take care of her when she first moved home, and offered to settle the case for $20,000. Simply said, cut me a check for $20,000 simply to compensate me for my medical bills, and I'll go away. And apparently they offered her $800 instead. I don't know where they got that number from. No one knows these things. They might not even know, but that's the fact. So she filed the lawsuit. And the lawsuit went to trial in New Mexico, which is where this all took place. And during trial, they debated, as you might imagine, the temperature at which coffee gets served. Now, here's the thing. I'll admit to you, I'm not a coffee drinker. The last cup of coffee I had, this is harder than asking me the last time I had a beer, because I can usually think of an event where I may have had a beer, but that's been years. A cup of coffee, probably 5, 10 years ago. I'm not a coffee drinker, but I know there are people out there who are coffee drinkers who get coffee every single day. Of course, coffee's turned into a whole other thing with the existence of places like Starbucks where you can get a big old thing like this. It looks like a big gulp. Costs like $19 and has all kinds of weird stuff in there that's not coffee, along with whatever is originally coffee. But McDonald's sells a lot of coffee. Literally millions of dollars of coffee they sell probably every day, if not every week. And it's one of the things that they know for a fact that if you're going to go into a restaurant for breakfast, you better serve coffee. So at trial, they had a huge debate about the temperature at which McDonald's served its coffee. And I believe that among the testimony that was elicited during the trial, it came out that McDonald's served their coffee at about 180 to 190 degrees Fahrenheit. Okay, and you might recognize the fact that water boils at 212. So this is a good 30, 20 degrees below boiling. Okay, but it's hot, but it's not boiling hot, at least not literally boiling hot. An argument was made that many other restaurants serve their coffee at about 140 degrees. Okay, so 40 to 50 degrees below what McDonald's was alleged to have served their coffee at. And it came out during the trial also that prior to this, McDonald's had gotten claims of about 700 people being injured by the hot coffee. Okay, so here's the question. Let's get back to the Seinfeld argument. Okay, in other words, doesn't everyone know coffee is hot? Okay, and so people say, Steve, if coffee's hot, you know it's hot, and you get injured by the hot coffee that you knew was hot. How could you possibly have a case for negligence? And in a negligence case, and I'm not going to get really heavily into this, but generally speaking, you have to show that somebody has a duty. They owe you a duty. And if they breach that duty and you're harmed as a result, then they can come after you for damages. And so the duty that they'd be alleging here is that the place that's selling coffee has a duty to sell it at a temperature that won't injure somebody in a foreseeable manner. Okay? And believe it or not, you could also probably couch this as a warranty claim because there's a warranty of merchantability with respect to goods that are served that are edible, meaning a restaurant. And if I serve you goods, I don't have to tell you, by the way, that hamburger I'm selling you is edible. It's presumed to be edible. That's the implied warranty of merchantability. So an argument could be made that if I sell you coffee and I tell you you can ingest this orally, i.e. eat it, that the coffee is safe and you can drink it safely, okay? So here's the question. I know everyone's thinking, they're going, but Steve, what you said right there, still everyone knows coffee is hot. Okay. So if I hand you a cup of coffee that's 150 degrees, just yanking numbers out of air, but 150 degrees, you can immediately take it, throw caution to the wind, and guzzle it. It'll be hot, but it's not going to injure you. Okay? If I sell you coffee that's 210 degrees, and I'm purposely picking a number at the far end of the scale. It's not quite boiling, but it's almost boiling. If I hand you a cup of that coffee and you go to drink it, it's going to burn you. It's going to burn whatever touches on your body. And for instance, let's suppose that I go to hand you a cup of coffee, and in the process of handing it to you, one of us bumps something and I spill it on your legs. Okay? Now, putting the coffee on your legs is not the intended purpose of coffee, but it's something foreseeable, isn't it? Isn't it foreseeable? And I'm giving a hypothetical here. If I go to hand you the cup of coffee and I lose my grip on it and it spills on you, and it injures you because it's so hot. This has nothing to do with whether or not the coffee is delicious or whether the coffee is going to give you a pick-me-up. This is simply talking about whether the coffee itself is an unsafe instrumentality. It is something that by its very nature could hurt you. Again, the coffee I'm talking about at 210 degrees, okay? So no one sells it at 210 as far as I know. I'm simply trying to prove a point here. If I take a cup of iced coffee that's way below room temperature, I could throw it at you and it won't hurt you. I mean, it might embarrass you, but it's not going to hurt you. So you have to recognize there is a spectrum, and here the spectrum is numbers. At one end we have iced coffee, and one end we have almost boiling, scalding hot coffee. Now, most people would recognize and say, yeah, you shouldn't sell the stuff that's scalding hot because it's presumably dangerous to do so. There would be people getting injured simply working in the restaurant because they'd bump something and spill some on themselves, okay? I went through a drive-through once at a Wendy's, and the woman went to hand me a big, super duper double XL, whatever size the biggest drink they have is, and she handed it to me by the lid. And as she handed it to me, she dropped it in my lap. And yes, I got about a half a gallon of Diet Coke on my suit and on my seats in my car. Okay? Now, I wasn't injured because Diet Coke was cold. But what if that coffee, and again, this is hypothetical, what if that was the coffee that's being served at 210 degrees? You go, oh, obviously, if they dropped the coffee in your lap and it burned you and sent you to the hospital where you had to get skin grafts on your hoo-ha, or if you're a guy, the equivalent, then you go, oh, but wait a second, yeah, they should be liable for that. So then the question simply becomes, on this scale, at what point does it stop becoming their fault and start becoming your own fault? So that was the argument they made at trial, that the Liebeck attorney argued and said, look, we're not arguing that coffee shouldn't be served hot. We're just saying it shouldn't be served that hot. So here's the thing. People love to think that jurors are stupid or that jurors love throwing around other people's money. And I'm here to tell you that most juries I've seen in civil cases are very loath to throw around other people's money. And I know you're going to say, but Steve, what about the... No. Let's not talk about the cases that make the headlines, because the cases that make the headlines by their necessity are newsworthy because they're unusual. I've actually been in a courtroom before where a judge told me, as I was preparing to go to trial on a case, she actually said, she goes, just to let you know, Mr. Lehto, I have not had a plaintiff verdict in 3 years in my courtroom. It's been 3 years since a jury gave a plaintiff anything. Okay? So jurors aren't always just writing checks with other people's money. So what happened in this case was a 12-person jury, 12 people, okay, a 12-person jury got together, and they did, in fact, award Stella $2.86 million. And they said part of that's compensatory and part of it's punitive because we think that McDonald's should lower the temperature at which they sell their coffee. But they also said, and we find that McDonald's is 80% at fault and Stella herself is 20% at fault, meaning we're going to reduce the award 20% because it's partly her fault. Not entirely her fault, it's not mostly her fault, but it's partly her fault. Okay? And then what happened, of course, is the defendants appealed the case. They actually brought a motion in front of the same judge and just said, hey, judge, we want a judgment notwithstanding the verdict, JNOV, which is Latin, which I won't get into now. But they said basically the jury award on the punitive damages in particular is out of control and needs to be reduced to be reasonable. And in fact, the judge did reduce the award. And the entire award got knocked down to $640,000. And then, just so you know that the story ends someplace else, after that happened, when both sides were talking about possibly appealing it, they settled, and the settlement was for less. That much was publicly said, that the settlement was for less than the $640,000. So here's the key. Again, Stella did in fact spill the coffee on herself. But the argument is that the coffee was hotter than the industry standard, or that it was hotter than it needed to be. And they've done marketing studies on this. And the question is, when you buy food when you're driving, do you eat it in your car or do you eat it when you get where you're going? And they've done studies that have determined that most people might sip a little of the coffee, but the bulk of it's going to get ingested when they get to where they're going. Many people pick it up on their way into work, for instance, okay? And so are you selling the coffee to be consumed at work or consumed in the car? Because if it's going to be consumed in the car, you sell it at a lower temperature. If it's going to be consumed at work, you sell it at a higher temperature. So just so you know, most of the restaurants now have larger warnings on the coffee cups telling you that, in essence, it might not be safe to drink immediately because it's that hot. And so that's really the point here. At the moment in time, they're handing you the thing they're selling you. Okay? Is it safe to use at that moment in time? If it's food, is it safe to ingest? And if it's a non-food product, is it safe to use? And like I said, that, again, remember, I'm a lawyer, so we often use hypotheticals just to understand things. And at the moment I'm handing you the cup of coffee, and it's at a temperature that will injure you if you spill it on your skin, to the point where you got to go to the hospital. The question is that too hot? And I don't think that's an unreasonable question. And there's 12 jurors in New Mexico who agree with me. So again, if you disagree with the outcome of this case, that's fine. There's nothing wrong with disagreeing with it. But if you're going to talk about the case, at least get the facts straight, okay? She wasn't driving. She was a passenger in a non-moving vehicle. That was, vehicle was stopped. There's no one argues with these questions, with these facts. She was stopped, and she went to open it. And it wasn't just an inconvenience like Kramer, where he got a thing of coffee down his pants and he looked stupid like he'd wet his pants. She actually required skin grafts and an 8-day stay in the hospital. I'm here to tell you that at my age, I've never spent an 8-day stint in the hospital. That is a very unusual thing. I wouldn't want to spend 8 days in the hospital, and I wouldn't want to get skin grafts down there, if you know what I mean. So that's the story of Liebeck versus McDonald's et al. There were a few other defendants in there as well. And like I said, Ms. Liebeck is no longer with us. She passed away a few years ago. There have been some very good things written about this and a documentary shot about it. So you can poke around the internet and look it up yourself. And again, like I said, you might not agree with this at all. Okay? And you're free to do that. This is America. But the point is, at least get your facts straight before you disagree. Okay? Otherwise, I hope you enjoyed it. Questions or comments? Fire them in the comments. Talk to you later. Bye-bye.